LiSTNR production.
On a quiet Sunday in March 2016, in the small Sydney suburb of Freshwater, a routine between two neighbours, Mae Richie and Bob Lyford, was broken. The pair gathered regularly to watch the football. But on that Sunday, Mae didn't turn up. Concerned, Bob used his spare key and entered Mae's apartment. What he found would haunt him forever. I'm Dan Mullins. This is Crime Insider's Judgment, a deep dive on a judge's final verdict of a crime and what transpired to incite that judgment. Standing in the lounge room, drenched in blood, was Bob's former fiancée, Marita Cunningham. The television was still on behind her, and Mae Richie was nowhere in sight. Cunningham was 50 at the time, a familiar name to Bob Lyford, too familiar. Just 3 years earlier, they had been briefly engaged. The relationship fell apart quickly, violently. Bob had taken out an apprehended violence order, or an AVO, against Cunningham. That Sunday afternoon, she showed up at his door. She left, but not far. She crossed the road and entered Mae Richie's flat. A neighbour later described seeing Cunningham on Mae's patio, clutching a wine bottle and a glass, dishevelled, stumbling, slurring her words. When Bob couldn't shake the feeling that something was wrong, he returned to Mae's flat. Inside, he saw blood on Cunningham's shirt. When he asked her about it, she said, "That's all from me." He searched the flat and found Mae covered by newspapers and pillows. She was covered in bruises and had been asphyxiated. Despite their best efforts, police and ambulance officers were unable to resuscitate her, and she was pronounced dead at the scene. The case went to trial in the New South Wales Supreme Court. It was a judge-alone trial, no jury. Marita Cunningham pleaded not guilty to murder. The Crown, led by prosecutor Craig Patrick SC, painted a grim picture, a woman scorned, acting with intention to kill or seriously harm. But the defence said this wasn't cold-blooded murder. It said Marita Cunningham was acutely unwell, suffering from schizoaffective disorder, hallucinations, delusions. The court would later hear a number of examples of acute mental illness. Cunningham's barrister, Belinda Rigg SC, argued that Cunningham wasn't legally responsible for her actions, that her mental illness meant she couldn't fully understand what she was doing. Not murder, they said, manslaughter, due to substantial impairment. So what do we do when someone kills but might not have understood it? What happens when illness and violence overlap? And what justice is there for a woman like Mae Richie? I'm going to read from the judgment handed down by Justice Robert Beach Jones in the New South Wales Supreme Court. A post-mortem examination revealed that Ms. Richie suffered from a number of blunt force injuries. The cause of death was asphyxiation. She may have been strangled or smothered, or both. Throughout the afternoon of March 2016, a number of persons exiting her unit block saw the accused and Ms. Richie at her unit together. They were seen drinking wine. At various times, they were talking and interacting in a friendly manner, although the accused's behaviour appears to have become disturbed as the afternoon progressed. Ms. Richie was last heard alive at around 7 p.m. The first issue that arose in the trial is whether the Crown proved beyond reasonable doubt that a deliberate act of the accused caused the death of Ms. Richie. For the reasons set out in the balance of this judgment, I am so satisfied. The next issue that arose in the trial is whether the accused is criminally responsible for her actions. On behalf of the accused, it was contended that the court should be satisfied on the balance of probabilities that she was mentally ill at the time of Ms. Richie's killing. If that contention was accepted, the court must return a verdict of not guilty by reason of mental illness. The defence adduced evidence from a psychiatrist, Dr. Ellis. The prosecution adduced evidence from a psychiatrist, Professor Greenberg. Both Dr. Ellis and Professor Greenberg diagnosed the accused as suffering from a schizoaffective disorder. The Crown did not dispute that diagnosis. Further, both Dr. Ellis and Professor Greenberg concluded that the accused was mentally ill at the time Ms. Richie was killed, in that both considered she did not know that her actions were morally wrong in accordance with the ordinary standards of right and wrong adopted by reasonable people. These conclusions were contested by the Crown. For the reasons that follow, I do not accept the Crown's contentions and uphold the defence of mental illness. In summary, I accept the psychiatrist's diagnoses and opinions, supported as they are by a very strong body of independent evidence concerning the accused's conduct and mental state right up to the time she killed Miss Richie and from the time she was arrested. Later, Justice Robert Beach Jones says, "The defence of mental illness is made out if the accused establishes on the balance of probabilities that, at the time of the act or omission that caused the deceased's death, she was labouring under such a defect of reason from a disease of the mind that she did not know the nature and quality of the act or omission, or, if she did know it, she did not know that what she was doing was wrong in accordance with the ordinary standards of right and wrong adopted by reasonable people." In relation to intoxication and specific intent, Justice Robert Beach Jones said, "There is evidence that the accused had consumed alcohol in the period prior to Ms. Richie's death. This evidence can be taken into account in determining whether the accused had the intention to cause death or grievous bodily harm, unless the accused resolved to become intoxicated before she allegedly killed Ms. Richie, or became intoxicated to strengthen her resolve to kill or inflict grievous bodily harm upon Mae Richie. There is no evidence that the accused made either decision." The court heard from two psychiatrists, Dr. Ellis and Professor Greenberg, and the officer in charge of the investigation, Detective Senior Constable Vickery. Witness statements were tendered by the Crown Prosecutor without objection by Senior Counsel for the accused and without any request to cross-examine the authors of the statements. In the end result, there was no contest over the primary facts which I will set out. Unless otherwise stated, I am satisfied of the following matters. As at March 20, 2016, Ms. Richie was 81 years of age. She lived in a two-bedroom unit in Foam Street, Freshwater. Her unit was located on the ground floor of an apartment block. An entrance to the apartment block was immediately adjacent to the door to Ms. Richie's unit. This door opened onto a small balcony at ground level. In the immediate period before her death, Ms. Richie's son Kenneth stayed at her unit 3 nights a week. On Sunday, the 20th of March 2016, he was visiting his children on the Central Coast. In 2015, Ms. Richie was diagnosed with dementia, although she was still capable of taking care of herself. Ms. Richie was relatively frail. She weighed 59 kilograms and was 1.61 meters tall. On the day in question, The accused was 49 years of age. She was 1.7 metres tall and her weight was somewhere between 80 and 90 kilograms. She lived by herself in a unit in Ronald Road, Narrowena. The accused's mental history is described in detail. At this point, it suffices to state that following the birth of her child in 2007, she developed severe postnatal depression. Subsequently, her mental health deteriorated to the point that she developed a schizoaffective disorder and other conditions. Professor Greenberg explained that persons with schizoaffective disorder have a combination of schizophrenic symptoms, that is, episodes of psychosis involving hallucinations, delusions, thought disorder, and disorganized behaviour, but also experience what's called a mood component, which results in manic and depressive symptoms usually associated with someone who is bipolar. In the period preceding the killing of Ms. Richie, Ms. Cunningham's behaviour had become increasingly disturbed. As of the 20th of March 2016, her condition was unmedicated. Robert Lyford lived in an apartment block at Wyadra Road, opposite Ms. Richie's unit. His apartment has a small balcony which had a direct view of Ms. Richie's balcony. As of the date of Ms. Richie's death, Mr. Lyford was 69 years of age. He moved into his unit in 2010 after the death of his wife. He had previously lived in Narrowena. When he lived in Narrowena, he and his wife met and became friends with the accused. He remained friends with her after the death of his wife. In early 2013, Mr. Lyford and the accused commenced a relationship. They were engaged for a short period. However, the relationship broke down. Mr. Lyford stated that in January 2015, quote, an incident occurred at my house, unquote, which resulted in an apprehended violence order, or AVO, being made against the accused, preventing her from contacting him for a period of 12 months. Coming up, in the judgment delivered by Justice Robert Beach Jones, what happened on the 20th of March 2016? Between 6:30am and 7:30am on the 20th of March 2016, the accused was seen by a neighbour, Annette Atone, in Ronald Avenue, Narrowena. Ms. Atone noticed that the accused kept looking down the street and was talking to herself. The accused attended the 8am service at St. John's Church in Narrowena. A parishioner, Matthew Aylward, observed a woman who I am satisfied he later identified as the accused acting strangely. He described her as fidgety and agitated. He said that she repeatedly creased and folded a church bulletin paper, which she dropped and picked up. He saw the accused clench her fist a few times, and her knuckles would turn white. Sometime between 11am and 11:30am, a neighbour of the accused, Ms. Hanson, saw the accused walking along her street in Narrowena. She described the accused as generally unkempt, dishevelled, and in a bad state. Ms. Hanson attempted to talk to the accused about the weather. She stated that the accused started to ramble and go off on a tangent and seemed a bit confused. Ms. Atone saw the accused again between midday and 1pm on that day. She saw the accused talking to herself and then howl like a dog. Ms. Richie visited Mr. Lyford's unit late in the morning on the 20th of March. She left in the early afternoon, but stated that she would return at about 4pm to watch the afternoon football game. At about 3:04pm, the accused boarded a bus in Narrowena and travelled to Freshwater. She got off the bus at 3:19pm. In his statement, Mr. Lyford recalled that around 3:45pm the accused knocked on the door of his unit. After answering the door, Mr. Lyford asked the accused what she was doing at his home. The accused stated that she had come to watch the football as the AVO had expired. Mr. Lyford said, "Fuck off. I never want to see you again. I don't want to know you." He closed the door. A number of residents who lived in the same block of apartments as Mae Richie corroborated Mr. Lyford's version of events. Back to the judgment. At around 5 p.m. to 5:30 p.m, another neighbour saw Mae and the accused talking in the apartment. At approximately 5:40 p.m, a neighbour, Paul Edgar, returned to Ms. Richie's unit block. He saw the door to Ms. Richie's unit was open. Inside, he saw Ms. Richie standing up and a female crouching down on the floor near her. Mr. Edgar said that Ms. Richie was just standing up next to her and she looked a bit worried. At about 6:10 p.m, after the football had finished, Mr. Lyford walked to his balcony and looked towards Ms. Richie's unit. He saw the accused and Ms. Richie seated in the lounge room of Ms. Richie's unit. He then called Ms. Richie's son Kenneth to tell his mother to urge the accused to leave. That call went unanswered. Shortly after 6:45 p.m, one of Ms. Richie's neighbours, Mr. Graham Marr, left the unit block through the exit near the entrance to Ms. Richie's unit. He saw Ms. Richie on the balcony of her unit and the accused come out of the unit holding an empty wine glass in one hand and an empty bottle of wine in the other. In his statement, Mr. Marr described the accused as dishevelled, stumbling and making noises. Mr. Marr saw Ms. Richie roll her eyes and make a gesture with her hand, which indicated to Mr. Marr that Ms. Richie thought that the accused was mentally impaired. Ms. Richie repeated the gesture. Mr. Marr formed the opinion that the accused was heavily intoxicated by something. At about 7 p.m, Paul Edgar's partner, Nicola Edgar, heard Ms. Richie talking to another female whom I infer was the accused. In her statement, she said the conversation sounded normal, although the other female's speech was slurred. Sometime during this period, another neighbour heard Mae Richie say, "That's not true. I'm single. Whoever said that is a liar." She then heard some noise and a woman's voice scream. I am satisfied that Kenneth Richie returned Mr. Lyford's call sometime prior to 7:55 p.m. At 7:55 p.m, Kenneth Richie twice called his mother's home phone, but she did not answer. Kenneth Richie then called Mr. Lyford, and Mr. Lyford agreed to go to Mae Richie's premises to check on her. Mr. Lyford had a key to Ms. Richie's premises. He walked to her front door. In his statement, Mr. Lyford said he knocked on the door and all of a sudden the lights went out. He recalled knocking on the door saying, "Mae, it's Bob. Are you all right, love?" He recalled that there was no answer, but I could hear noises from inside. Mr. Lyford unlocked the door and entered. The front door leads immediately into the lounge room of the unit. After opening the door, Mr. Lyford saw that the television was on in the lounge room and that the accused was standing about 1.5 meters from him. He said to her, "What are you doing here?" The accused replied saying, "Get out or I'll call the police." Mr. Lyford said, "By all means call the police, because if you don't, I will." Mr. Lyford saw blood on the floor. He said, "What's all the blood?" The accused said, "That's all from me." Mr. Lyford recalled that the accused moved forward and started to push him back to the front door. He pushed past her and turned the lounge room light on. The accused immediately turned it off. Mr. Lyford walked past the accused and turned the kitchen light on. Mr. Lyford checked the bedrooms and the bathrooms. The accused remained in the lounge room. Mr. Lyford said, "Where's Mae?" The accused said, "She got a bottle of wine and headed over to your place." Mr. Lyford did not believe her. At around 8:10 p.m, Mr. Lyford rang the police on his mobile phone and asked them to attend. The police officer who received the call recalled Mr. Lyford stating that Marita's here and she's going off, and he could hear a female in the background speaking. Mr. Lyford observed the accused rummaging through some bags on the ground floor of the lounge room. He recalled that she said something about needing to find her keys so that she could leave. Mr. Lyford looked for Ms. Richie in the bedrooms and bathroom, but could not find her. After returning to the lounge room, he checked Ms. Richie's handbag, but could not see her purse. Mr. Lyford saw the accused walk out the front door. He followed her. As he did so, 2 police officers arrived. The officers recorded their arrival time as 8:17 p.m. Marita Cunningham was arrested after trying to flee the scene. In the meantime, Mr. Lyford re-entered Mae Richie's unit. He noticed that the lounge room was messy with newspapers and cushions spread everywhere. He tried to find the remote control for the television. He moved some newspapers on the floor and found Ms. Richie's leg. She was covered in newspapers and cushions. Despite the best efforts of Mr. Lyford, the police and ambulance officers, Mae Richie was pronounced dead at the scene. Justice Beach Jones provided a summary of his findings in the New South Wales Supreme Court. The first issue that arose in the trial is whether the Crown proved beyond reasonable doubt that a deliberate act of the accused caused the death of Ms. Richie. He later says, "The only rational inference in the circumstances is that it was the accused's deliberate act that caused Ms. Richie's death." The next issue is whether the accused is criminally responsible for her actions. On behalf of the accused, it was contended that the court should be satisfied on the balance of probabilities that she was mentally ill at the time Ms. Richie was killed. If that contention was accepted, the court must return a verdict of not guilty by reason of mental illness. The defence provided evidence from the psychiatrist Dr. Ellis. The prosecution provided evidence from a psychiatrist, Professor Greenberg. There was also tendered a significant amount of evidence in the form of witness statements and health records concerning the accused's mental state and behaviour. This material revealed that in 2008, the accused was diagnosed with a schizoaffective disorder and has been affected by that condition since that time. The material also demonstrated that from the period January 2016 to the date of Ms. Richie's death, the accused's mental state deteriorated rapidly. There were almost daily instances of her engaging in antisocial or psychotic behaviour. Overall, I find that Dr. Ellis's and Professor Greenberg's diagnoses and opinions relied on and were supported by a very strong body of independent evidence concerning the accused's conduct and mental condition right up to the time she killed Ms. Richie and from the time she was arrested. The weight of that material points strongly to the accused suffering from mental illness when she killed Ms. Richie. I am satisfied on the balance of probabilities that at the time she killed Ms. Richie, the accused was labouring under such a defect of reason from a disease of the mind, namely a schizoaffective disorder and its effects, that she did not know that what she was doing was wrong, in accordance with the ordinary standards of right and wrong adopted by reasonable people. It follows that I will enter a verdict of not guilty by reason of mental illness. Thanks for listening to Crime Insider's Judgements. We love hearing your feedback, so please rate and review this episode. If you have a case you want us to cover, let us know via Instagram at LiSTNR Crime or TikTok at LiSTNR Crime Team. I'll be back again next Thursday with another case. I'm Dan Mullins. Thanks for listening. This series was recorded and produced on Gadigal land.